Welcome everyone to this Privacy Rules, Privacy Espresso episode. Privacy Espressos are quick sessions where we discuss with our experts from all over the world about privacy, data protection, and cybersecurity issues. Today, I'm joined by Padraig Walsh from Tanner De Witt in Hong Kong, where he is a partner and one of the leading experts in privacy and data protection. So I'm very pleased to have him with us today. So welcome, Padraig, and thanks for being here.
Great to speak to you again, Alessandro. Looking forward to this espresso.
Padraig, yes, thanks a lot. And let's go very quick through these. We discussed about some changes in the horizon there in Hong Kong. So we would like to take advantage of this espresso to receive a brief update from your side. Can you just give some insights on what's happening there right now?
Certainly, Alessandro. Well, these proposals were announced, at least in the fact that they are pending, and legislative proposals will be brought forward in the coming term in relation to four specific topics. Firstly, the introduction of regulation of data processors, limited regulation, but nonetheless some direct regulation in certain circumstances. There will also be an introduction of a mandatory requirement for businesses to have a data retention policy. There will be the introduction of administrative fining powers of the Privacy Commissioner for Personal Data, which is the regulator here in Hong Kong. And also there will be the introduction of a mandatory personal data breach reporting obligation. So four key changes, of which the two that have attracted the most attention are the data breach notification change and the data retention policy change. And those two changes actually are quite interesting. One of the things that's quite a surprise in respect of international businesses that operate in Hong Kong is that there isn't as yet a mandatory data breach notification obligation as a matter of general law. In certain of the regulated sectors, such as financial services, it will arise as a consequence of that regulation. But of general application, there isn't that statutory requirement as yet. There is a recommended best practice insofar as the PCPD is concerned, and it is something that would be adversely commented upon by the PCPD in terms of investigation reports, but it's not a mandatory requirement. So that's really a catching up to international standards and norms, combined with the administrative fining powers. That will be, a very strong incentive for businesses to drive the behavior around data breach prevention, because the consequences of firstly reporting and secondly there being turnover-based fines for breaches of obligations, that combination is a cocktail that should drive businesses to focus on cybersecurity and data security as a prime business issue. Now, on the data retention side, in order to have a good and effective data retention policy, you need to know the personal data that you actually have. This will drive a culture where businesses have to do data inventories in a dynamic way, so they know the personal data that they're holding, the points of access, the uses they're applying it to, as well as the life cycle for that personal data, matched with a policy around the destruction and deletion of personal data after the period of time for which the personal data was collected. The thing about that is, if you look at data breaches generally, the strongest mitigation measure, even if there is a hack or a data breach, well, if you could have minimized the personal data that's affected by that if you only retained personal data for the minimum period of time necessary for the uses for which it was collected. That's the target that the PCPD is targeting.
Perfect. And this is not only very interesting, but also really a good advice for companies on how to manage the data they have stored. In that regard, Padraig, I remember that proposal and regulation on those topics were already discussed in Hong Kong, but still, not implemented, if I'm not mistaken. So is all this entirely new or something that you already had there and that is coming back at a high-level issue to be addressed?
These proposals were actually first announced back in 2020, so some time ago. And data privacy and privacy advocates generally in Hong Kong were really looking forward to a significant updating of a data privacy regime that was actually one of the longest standing in Asia, but hasn't been really updated to international norms for a number of years. years. But since then, the proposals were in a holding pattern, and now they have been revived with proper intent in respect of bringing them forward. And I think there's a real momentum behind bringing forward the legislative changes. There are a number of drivers for that, but I think the key driver is that there is a policy generally of closer alignment and integration with the rest of China. And one of the things that's essential to that is to have proper systems in place, proper procedures to facilitate data transfers between mainland China and Hong Kong and vice versa. And the closer that the data privacy laws are to each other, then the easier it is for those transfers to occur. In the past couple of years, and last year in particular, there were transformative changes to personal information protection in mainland China, to the extent that now in the PRC, the standards for personal data protection are pretty much to a GDPR, and in some cases even stronger protection again than GDPR. Whereas in Hong Kong, those kinds of reforms and those kinds of developments have not occurred. And I see that the impetus for this particular change is that as a matter of gap analysis, it's easier for personal information to be transferred from mainland China to Hong Kong in circumstances where the statutory protections in respect of personal data are closer to the standards that apply in mainland China. And I think there's an element of that is also driving the legislative intent at this point in time.
Thanks a lot. That's extremely interesting. And what you're telling us, and I was also making some maths with the legislation in China, and makes sense to have Hong Kong implementing this right now, probably after taking the right time to understand how the new laws coming from China are implemented as well. So as you were rightly saying, is not a case that Hong Kong is moving right now.
Yes, I think that is the main driver. At the moment, for personal information to be transferred from mainland China to Hong Kong, the transferring party in mainland China needs to be assured that the personal information receives the same level of protection in Hong Kong as it does in mainland China. And that is largely true. But if there's too much of a gap in respect of the statutory standards, then you're providing that assurance more by virtue of contractual measures and contractual means than by the statutory and legislative framework. And it's to try and narrow that gap, I think, is one of the drivers that is behind the current legislative changes. That's just a personal opinion.
Yeah, perfect. And thanks a lot for sharing it with us. And staying on those new activities from the Hong Kong point of view, do you think there should be any other topic to be addressed other than the ones you mentioned, also in light of other regulation, for example?
Well, I think there are a number of things that have been long on the minds of privacy advocates in Hong Kong. And probably one of the more interesting ones on which there is no present development is the regulation of international data transfers. There is in our personal data privacy ordinance, there's a section that has been there from the outset, so right way back to 1996, but has never been brought into force. And that's effectively what EU and GDPR terms would be called an adequacy regime for international data transfers. Hong Kong doesn't have that system. It's not to say that there aren't rules that apply in respect of international data transfers, but we don't have the equivalent of a whitelist for accepted jurisdictions of equivalent standing or other mechanisms and means and processes in order to facilitate or encourage international data transfers. And that's one of the things that has long been advocated as something that should come into force in Hong Kong. There's no particular sign of that as yet. Occasionally it comes up in conversation. There was a feeling maybe about 7 to 8 years ago where there was a push again to try and bring Section 33 into force, but there was pushback from industry, and then it was put on ice and put to one side for the time being. So that may be one area that comes under renewed focus going forward. But you thank the powers that be for bringing forward good, positive change. And that becomes then a platform on which other developments could then be built in the future.
Perfect, Padraig. And we are also running out of our time. So thanks a lot for this quick overview. I would invite everyone dealing with Hong Kong business to contact you for any further support. As you may have seen, there is a lot to have a look at. So thanks a lot for being with us. To you and our listeners, I invite you all to join our next Privacy Espresso next week. So looking forward to meet you all there.
Thank you, Alessandro.